On with it then. Good afternoon. This is House Judiciary Committee. It is the 22nd of January, 2025. We have several bills before us, and so we should get on with it. So let's hear with House Bill 249. Delegate Polakovich-Carr, if you want to bring up whoever you would like to bring up with you. Oh, you and Laurie Ruth, which is the sum total of witnesses on this bill. So we will give you 3 minutes. We'll give Ms. Ruth 2 minutes, and please go ahead.
Good afternoon. For the record, I'm Delegate Julie Polakovich-Carr, here to present House Bill 249. This bill would close an accidental loophole in legislation we previously enacted to protect residents from unjust eviction. In the 2023 legislative session, we passed a bill to ensure that Marylanders can summon police, fire, or medical services during an emergency. That legislation said that local governments cannot penalize property owners or their tenants solely for the act of calling for police or emergency assistance. That legislation was needed because there are a very small number of local governments in Maryland that have adopted local laws that fine property owners for repeated calls for emergency services. Some local governments in our state fine a property owner for as little as 2 calls to 911. And some of these local laws are drafted so broadly that they end up punishing victims of crime who legitimately need help. It's well documented by a variety of sources that nuisance laws are discriminatory against victims of domestic violence, people of color, residents who are LGBTQIA, and people with disabilities. Also, nuisance laws put tenants at greater risk of eviction even if they didn't do anything wrong. So that's the backstory. The bill before you today is needed to correct a drafting mistake in the 2023 law. It was always my intention to prohibit local governments from enacting and enforcing a local nuisance law that is based on calls for emergency service. I testified to that end before this committee, as did other witnesses. However, based on the way that the bill was actually drafted, local governments are prohibited only from enacting nuisance laws, but not from enforcing local laws that predate the state law. And let me be clear, as the sponsor of that prior bill, I take full responsibility for that. I'm certainly not blaming our very hardworking staff in DLS. So along with my written testimony, I've uploaded a copy of an advice letter that we received from the Attorney General's office. And that letter says that the legislative history of the 2023 bill, quote, reveals a clear intent by the General Assembly to preempt both local enactment and enforcement of local law, end quote. So HB 249 simply seeks to correct the language of state law to match our legislative intent from the 2023 session and to make sure that every Marylander has access to emergency services without fear of retaliation by their landlord or local government. And finally, I would like to note that the Maryland Municipal League had originally submitted written testimony in opposition to the bill, but with some subsequent exchange of information, they have withdrawn their opposition. They are not taking a position on the bill. So thank you for your time and consideration, and I hope that we can correct this error. Thank you.
Good afternoon, Mr. Chair, Madam Vice Chair, members of the committee. My name is Laurie Ruth. I am the Public Policy Director at the Maryland Network Against Domestic Violence. Our good friend Melanie Shapiro has moved on to the Criminal Injuries Compensation Board. So you've seen me here over the years for a different organization, but now I'm with the network. The network fully supports this bill. I've also been authorized to say that the House of Ruth supports the bill. Unfortunately, they lost track of time and didn't submit anything. And I think the delegate, thank you very much for bringing this, but also I think she's really told you everything you need to know. I will just emphasize that, you know, laws like this that punish people for calling law enforcement or emergency services compromises the safety of victims and survivors of domestic violence. Because they have to choose essentially between trying to seek help when they're in danger or need help and keeping their housing sometimes. And we know that housing instability is one of the big factors in domestic violence, and laws like this just make it worse for them. The other thing is that the Fair Housing Act and VAWA, the Violence Against Women Act, extends housing protections to intimate partner violence victims. And so laws like this one that needs to also not be enforced if it already existed, make it worse for them. And for those reasons, we ask for a favorable report. Thank you.
Questions, Delegate Simmons?
Thank you, Mr. Chair, and thank you all for coming out. How are we doing? Just can you expand a little bit more on the punishment? I heard the word punishment used. What does that look like? And also, do you have the support of the FOP or the Chiefs Association, any of our law enforcement? They was referenced in the speech in reference to supporting this bill or in opposition of the bill.
Yes, let me start with your second question. No law enforcement group has weighed in on the bill. They didn't in the prior legislation either, but I will say that we worked very closely with MACO in pulling together the original legislation, so they would also be reflective of their local police departments, and they were good with what we had passed. In terms of the punishments, it's usually a monetary fine that these local governments are putting upon the property owner. Could be a few $100s, but in some cases they do ramp up. But really, I'd say the people who are ultimately bearing the price are tenants in rental housing, because some of these jurisdictions make a proactive point of notifying the landlord as soon as one call for service happens at the property. As soon as just one time police are called out or fire EMS is called out, they'll notify the landlord, and then the landlord usually will evict the tenant at that point.
Okay, I guess what I'm trying to get to is what would be an example of a call for service? So is it loud noise? Is it drugs? Like what would?
It's a fairly comprehensive list in most of these jurisdictions. They can differ a little bit from place to place, but it could be petty crimes. It could be more serious crimes. But I'll note that the key is with the bill we passed in 2023 is we were saying that you can't base these local nuisance laws off of calls for service. There are other jurisdictions in Maryland that have their nuisance laws based off of, say, arrests or convictions or police reports, and state law fully allows those to go forward. So the remaining 5 jurisdictions at this point that have nuisance laws based off of calls for service could just easily amend their local laws to use some other standard.
Yes, and maybe to thank you, Mr. Chair, and maybe to help Delegate Simmons, for my, as part of having cerebral palsy, I fall a fair amount, and so is it possible that my good friend from District 12B was talking about crimes and drugs and things like that, but is it possible that potentially somebody with CP who falls a lot and can't get up on their own would get fined under this proposal? So it's also helping grandma and people with disabilities as well, but they're fined just because of their disability and needing to call more often?
I think
is
that's
that a fair assessment?
Yes, I think that's a very fair point, Delegate Kaufman. And there is some data that shows that especially people with disabilities tend to be disproportionate victims of local nuisance ordinances. And when the committee did hear this bill a few years ago, I'll note we had testimony about a resident who had a disability and had an accident in their kitchen, and the fire department needed to be called out. There wasn't actually any physical damage to the apartment, but fire was called out, and then that person with a disability was evicted, ultimately because of their disability.
Thank you, and a brief yes or no question. Does the Maryland Developmental Disabilities Council support the bill? They do.
They do, yes.
Delegate Simmons, you coming back? Okay.
Just follow. Thank you. Do we have any data in reference to what we're speaking about today? Any numbers of these calls or how much we're talking about?
I'll follow up with you. I have data from when I brought the bill in 2023 that we MPIA'd from local jurisdictions. We don't have a full data set at this point, but I can circle back with you. It varies a lot by jurisdiction.
Does anyone else have any questions? Seeing none, thank you very much. That concludes the testimony for House Bill 249. We'll go on now to House Bill 240 and Delegate Young, who just arrived. And it is Delegate Young. That's fine. Go ahead. House Bill 240.
Thank you, Mr. Chair. Members of the Judiciary Committee, pardon my tardiness. We were running from a joint hearing room. We just wrapped up over there. Today, I will be talking about House Bill 240, which is a reintroduction. With me today is my intern, Daniel Mosley, who will present the bill.
Good afternoon. My name is Daniel Mosley. I'm currently a student at Howard County Community College studying business administration. I also intern for Delegate Young. We are here today in support of HB 240. HB 240 is a reporting bill on the implementation of text messaging systems for the court. It will help defendants, lawyers, and others know when they are needed in court. It passed last year through this committee, and we are asking for your support and a favorable report. Thank you.
Delegate Eric Hammond.
Thank you, Mr. Chair. Good to see you again. We miss you. That was for your boss, sorry.
I get you.
Anywho, what happened? Where did we get hung up on this? This seems so reasonable. What was the story?
Just didn't get through the across the street.
Oh, okay. So we know who to hate and punish then. Okay, thank you.
Any other questions for this panel? Did a very good job. Is this your first bill that you've testified on?
Yes.
Talking to the
I'm a little
delegate,
nervous.
but is this your first? Yeah, good job. All right. With no other questions, that concludes the bill hearing on House Bill 240.
Thank you.
Thank you both very, very much. Good job. Thank you very much. House Bill 74, Delegate Foley is here with a bill that looks vaguely similar to something else. House Bill 74, who do you want to bring up? Coming up
Yes, thank you,
anyway.
Mr. Chairman. I have a panel of several people, Dominic Butchko, Rebecca Snyder, gentleman from the Daily Record, and one of my witnesses is testifying on another bill, so he may be here, he may not, and I'll say something about that
Jonathan
at the end.
Schluss?
Yeah, he's testifying on another bill at the moment.
We have one person virtually, he's here. Let's go ahead and bring him in, and then that'll be everybody. And so we'll just hear from everybody all at once. Delegate Foley for 3 minutes, everybody else for 2.
Thank you, Mr. Chair. Good afternoon, Chair Clippinger, Vice Chair Bartlett. For the record, I'm Delegate Linda Foley, and I'm presenting HB 74, legal advertisement or legal notice publication in newspapers of general circulation, digital newspapers. Thank you for the opportunity to speak in support of this bill. I think you'll like it. As a former journalist and former president of the union representing news workers, I believe it's crucial that we update our state laws to keep pace with the changing media landscape. The rise of digital media publications has dramatically changed how the public accesses information, including legal notices and advertisements. In addition, the finances and scope of local media in Maryland has changed drastically since the legal notice statute was first enacted. For some context, the Merrill School of Journalism at the University of Maryland recently conducted a comprehensive study that provides a snapshot of current local media landscape in Maryland. We all know how critically important locally based, journalistically sourced news outlets are to the functioning of our communities and democratic governments that run them. The study is attached to my written testimony, and I recommend that you take a look at it. The Merrill study found that there are 176 local media outlets in Maryland, 156 of which are focused on news and journalistically supplied content. 78 of them are print-based newspapers that also publish websites or PDFs of their publication. 53 are digital-only publications. The study also looked at the geographic landscape of Maryland's media, and I could go into that, but I'm going to skip that for time's sake. So while the number of media outlets, traditional or legacy media outlets in Maryland is shrinking, the number of media outlets in the state as a whole has actually grown since 2020, with all the growth coming from startup digital media. It's important that local media outlets be supported. It's also important that there be regular independent notice of local government functions available to members of the community. Local independent news outlets are the best vehicles to fulfill this mission. Solely posting required legal notices on government websites is contrary to basic transparency and the constitutional role of a free press. That's why current law has clear requirements for the publication in independent media of legal notices and advertisements by counties and municipalities across Maryland. This bill would allow that notices be published in either print or digital formats, providing access to the widest possible audience, and at the same time, providing some cost savings for some municipalities and counties. Importantly, HB 74 also mandates that any digital publication running these legal notices must have an archive accessible to the public and employ at least one employee focused on reporting local news and information. This will help guarantee that legal notices remain readily available and are accompanied by context and analysis that citizens need to stay informed. It also guarantees that any digital publication containing legal notices is a legitimate ongoing concern. A similar bill covering just Dorchester County was passed last year by the General Assembly. For all these reasons, I urge a favorable report on HB 74 so we can help bring Maryland's public notice requirements into the 21st century. Thank you very much, and I'll be happy to answer any questions.
Good afternoon, Chair and members of the committee. I'm Rebecca Snyder, the Executive Director of the Maryland, Delaware, D.C. Press Association, and we do stand in support of this bill. It is not a radical rethinking of public notice. Public notice is meant to be an independently operated and published entities, which is why it's always been in news media. This bill would require that, or would allow, and it's really to fix a timing issue more than anything else. If, as the media landscape has changed and print publications maybe decrease their print days, certainly in smaller jurisdictions such as Dorchester, which we worked on last year, they were having difficulties publishing their notices in a timely fashion because of the print deadlines. We shouldn't get hung up on format. We should get hung up on independence. We should get hung up on clear delineations of audience and understanding who is reading notices. And so what this bill allows is for the proverbial clock to start on a notice at the point of publication, whether it's in the digital format of that traditional publication or in the print. So sort of whatever deadline works best for the government body. And so I think it's important also to recognize what this bill, it's tailored in scope. It focuses only on governmental entities, so local governments placing their notices. It doesn't affect any other notice. And although the Dorchester bill went into effect October 1st, so it's not like a huge body of history on there, I did make sure to check in with the publications in that jurisdiction, in that county, to make sure that there weren't any unforeseen consequences. There are none. And so we do feel like this is a way to help custodians and preserve public notice, and we urge a favorable report. Thank you.
I'll go. Mr. Chair, members of the committee, Don Butchko with the Maryland Association of Counties. I really can't state more than these professionals did on how great this legislation is. I urge you to read our written testimony, and I urge you to give it a favorable report. Thank you.
Good afternoon, Mr. Chairman, Madam Vice Chair, members of the committee. I'm Lorenzo Bellamy here on behalf of the Daily Record. We appreciate your readership, both print and digital, and look forward to having more conversations with you. We are here in full support of House Bill 74 and thank Delegate Foley for introducing this bill. Again, Ms. Snyder and the delegate have already explained what this bill does, and so we are available to work with you and the rest of this committee and any of those that support this bill to make it through the finish line. So thank you very much, and we urge a favorable report on House Bill 74.
Let's hear from Mr. Lonergan Seeger, please, for 2 minutes.
Good afternoon, Chair, Vice Chair, and members of the committee. On behalf of the City of Gaithersburg, thank you for this opportunity to testify to support with amendments HB 74. The bill established requirements for publishing legal advertisements and notices in counties and municipalities across Maryland. It allows these publications to be in digital format if the digital publication maintains an archive and employs at least one employee for reporting, writing, or editing local news and information. City of Gaithersburg has long advocated for changes to the laws mandating print advertising of legal ads and notices in the newspaper of general circulation. These arcane requirements cause the city's taxpayers to expend more than $15,000 annually for costs associated with print advertising of legal and other public notices that largely go unseen by its residents. Public notice requirements should fundamentally consider whether the advertisement reaches its intended audience and should accurately reflect modern-day information sharing processes. With websites, the proliferation of social media and other online sources to disseminate information, local governments should not have to continue to follow antiquated advertising requirements to pay print newspapers of varied circulation and accountability to distribute notices which can be shared electronically, often at a lower cost and reaching targeted communities more effectively. While we generally support the direction and intent of this bill, we respectfully request an amendment under Article General Provisions that would expand and further clarify the definition of a newspaper or newspaper in general circulation to mean a publication that engages professionals to create edit, produce, and distribute original content concerning matters of public interest through reporting activities, including conducting interviews, observing current events, or analyzing documents and other information, and has at least one employee employed full-time for 30 hours a week or more dedicated to providing coverage of the community. Thank you in advance, thank you again for your consideration, and we urge a favorable report.
Starting with the vice chair, then to Sample Hughes.
Thank you. Thank you, Mr. Chair. And my question is for the gentleman from Gaithersburg, who, is he still around? Okay, great. Your amendment is extremely precise and very detailed. Why?
I would say primarily because the newspaper to which the city and several others in Montgomery County have been relegated for some time has been the Washington Post. And frankly, it is not what we consider to be a newspaper that covers the community directly. Occasional reports here, occasional news, but the fact is that our residents are not generally turning to it for hyper-local information, and certainly not turning to it for public notices. That's not how they're learning about what's going on at the city level.
I have a follow-up question with a different person. This is for the delegate, Delegate Foley. Do you agree with that? Do you think that your bill would only be limited to the Washington Post?
The short answer to that, Madam Vice Chair, and thank you for the question, is no, I don't think it's limited to the Washington Post. I think that there are some misconceptions out there among local officials about where public notices need to be placed. Having said that, I think that it is important that they be placed in media that the community members actually can see and can access and have a connection to.
And if I could have one more? One more. And this is for Rebecca Snyder. Okay, so what is the definition of a newspaper?
Well, by statute in Maryland law, a newspaper of general circulation requires there to be a publication that is offered for sale, basically has a clear audience, that has a second-class periodicals permit, has been in business for at least 6 months with an established place of business, regular frequency. So it's sort of about the business practices and covers news and events of the community. And the community, that's a fungible term, but it's meant to, that definition is meant to get at the news gathering aspect, and that there's consistency and that there's a history there. So you can't just pop up and say, I'm open for business, give me these notices, and then pop out the next day.
Okay, thank you. Thank you, Mr. Chair.
Delegate Sample Hughes, the toll.
Oops.
Thank you, Mr. Chair, and thank you, Delegate, for the bill. I just wanted to get clarity on just two things. One, when you say Dorchester County was ahead of the curve on this,
Is this bill specific?
Delegate, I would definitely say Dorchester County was ahead of the curve on this.
Wonderful, wonderful. Now then, I guess all my clarification questions have been answered. No, I do have two more, though. One regarding, so this is a MACO-supported bill?
Yes.
Okay, and then, you may have said that already. Then the other part is the research that you did, ma'am, on regards of the impact and unintended consequences. Mm-hmm. Were you referring specifically to the financial, any impact that may have occurred?
Well, I wanted to check, really, it was, that bill came about to fix a really specific timing issue, and I wanted to make sure the problem was solved. Like, are the commissioners able to place in the way that they want? Did it cause undue distress for the publications? You have 2 in Dorchester County that take those notices. You know, did the sky fall? Were they able to publish appropriately? Was there confusion? Were there ads that were dropped because, you know, you didn't know if they started first in online or in print? And that didn't happen. And so I didn't expect there would be a lot of trauma and drama around that, because we did, at the Press Association level, convene a group of publications who take these type of notices and talked about it. Be like, okay, how can we make sure that we're fulfilling our obligation? It is, it's an important public obligation to be the record holder of a community, and we didn't want to drop the ball. So we felt confident about it, but you never know until you actually put it in place. That all being said, October was not that long ago.
Right. I recall a time where there was an entity that was very much in opposition, and we took a lot of heat from even introducing the bill. It's been some time ago. But anyway, it was regarding any financial impact that could potentially happen to those media outlets. And so that's why I was trying to really figure out what you found out.
And so that has not changed because the entities have not really changed. Okay. So the Dorchester Banner and the Dorchester Star are still your public notice organs, your publications. And so that has not, whether an ad is placed by the commissioners in the online version for expediency's sake or the print version, really doesn't make a significant difference to the economics of it. It's more to the logistics and the format, and we wanted to make sure we didn't drop the ball.
Okay, thank you. Thank you,
Mr. Chair, may I add something to that? Thank you. So I just also want to point out that in my testimony and also in the study by the University of Maryland School of Journalism, that there are 156 local news outlets in Maryland by their definition, which largely follows what Ms. Snyder said. And 131 of those have digital components or are digital only. So the economic impact will be on a very small number of these media outlets. Some of them in the Maryland study, by the way, are broadcast media. So that's that's not even in this universe here. Thank you.
Delegate Holt.
Thank you, Mr. Chair. I think I've read this further, and I think I clarified my question, but I'll just ask you just to be sure. This is in addition to print as well. You're asking that to be updated for print. I mean, you're not taking away print, in other words. Okay. Or you determine of putting legal notices in print.
Right. Delegate, no, we are not taking away print. This is another option.
Another option. Okay.
Yes, ma'am.
I think I read that. I just wanted to double check. And for the record, this will be a charge for individuals when you put the legal notices, even for a digital version, they will be charged to do this.
I would be shocked if they weren't, but I think the answer to that is yes.
For Daily Record?
That is correct.
Do you know the cost it would be?
I don't know the cost offhand.
Delegate Thompson. Two things that I'd like to clarify and add. So the ads, even if they start off in the digital version, just again for expediency, for that timing, they'll still show up in the print version. So the physical archive and print, which we feel is very important because you can't really change print, it's there. That's your record in an archive. That still exists. It's really about when the clock starts. And then regarding charges, this bill is focused on notices that are placed by government entities. Okay. So it's not individuals who are paying the bill for that. It is the statutorily required notices that governments need to place, usually around taxes, zoning. There's a whole host of required publications, and that is, what I find, and I don't get into pricing with my members, that's not my lane. But what I can tell you when we were talking about this in Dorchester County is that because it is part of the public trust, many of our publications are below market rate for these types of notices because they think it's an important part of their mission, and they really do work with government as much as they can. Gaithersburg, notwithstanding in their feelings of high rates, when you think about $15,000 on a county budget, that is, or even a city budget, that is a very small amount.
I would kindly push back on that. I mean, as a former local government person, any amount you pay, I'm still paying it as a taxpayer, so every dollar you spend is still going to be, still is important, so. I'm good. Thank you, Mr. Chair. I asked my questions answered. Thank you.
the Vice Chair for a second bite.
Thank you, Mr. Chair. My question is for Mr. Longren-Seeger. So I'm at your amendment still, and I wanted to understand the second part of your amendment that says that the newspaper as defined has at least one employee employed full-time for 30 hours a week or more and living within 50 miles of the coverage area. Does that mean the employee has to live within 50 miles of the coverage area?
I think that was the hope, that it's somebody that understands the community and reports on the community, with all due respect, because again, not to single out the publication in which we've been advertising for so long, but it does cost the city a lot of money. $15,000 is at the low end of what we spend annually. And the feedback we get from the community is that they are not reading about these responses in that particular, or sorry, about these notifications in the Washington Post. And the feeling about this amendment was that if it's going to be considered a newspaper of general circulation for the community, they should know about the community, report about the community, not just because we are in the Washington suburban area and that is the newspaper to which we have been, frankly, assigned for many years. That's the spirit behind it.
I see. Okay, thank you very much.
Thank you.
Are there any other questions for this panel? Seeing none, we thank you very much.
Thank you, Mr. Chair.
That concludes
And
the
committee.
testimony on House Bill 71. We now are going to go to House Bill 261. Delegate Forbes, who's bringing up bringing up herself and one other person, her panel, and we'll have them come on up. Register of Wills for Baltimore County, Ms. Burrell Road. All right, that's fine. So we'll hear 3 minutes from the delegate, 2 minutes from the Register of Wills. Please go ahead.
Thank you so much. Good afternoon, Chair Clippinger, Vice Chair Bartlett, and members of the Judiciary. I'm Delegate Kathy Forbes, and I appreciate the opportunity to present HB 261, a bill that will elevate the claims of unpaid child supports in estates so that more of those claims will get paid. As you may know, Estates and Trusts 8105 sets forth the priority of payments and claims of an estate. This list comes into use when the estate doesn't have enough assets to cover all the claims filed against an estate. Claims are paid in the priority of this list. Number 1 on the list is fees due to the Register of Wills, followed by 2, cost of estate administration, 3, funeral expenses, 4, compensation of personal representative. The list goes down until number 11, all other claims. Claims are paid in the order of this list, and when assets run out, the lower claims do not get paid. Currently, unpaid child support owed by the decedent at the time of their death is part of number 11, all other claims. It is given the same priority as credit card debt. Essentially, everyone gets paid before these unpaid child support claims. This bill proposes to elevate claims of unpaid child support to number 6 on the list. If a parent has failed to pay child support during their lifetime and then passes away, the parent of the surviving child has the right to file a claim against the estate for unpaid child support. The current placement of that claim on the bottom of the list reduces the chance of that child support ever being recovered in an insolvent estate. The passage of this legislation will elevate those unpaid child support claims to ensure that children get what they are due. I would argue that payments made for the benefit of a surviving child means more to that child that has lost a parent and that child's family than payments to creditors listed below that are institutional and business entities and have more resources to absorb a lack of payment. This idea for legislation was brought to me by the Register of Wills from Baltimore County, Alexis Burrell Rohde. I'm happy to have her here to testify in favor of this bill, and I'm also happy to answer any questions. I thank you all, and I ask for a favorable report.
Please.
Should I start? Okay, thank you. Thank you, Chair Clippinger and Vice Chair Bartlett. My name is Alexis Burrell Rohde. I'm the Register of Wills for Baltimore County, and I'm really pleased to be in front of this committee to hear what I think is a really simple but yet important bill that will really make a difference in families' lives in Maryland. And Delegate Forbes went into a lot of detail, and so I don't really have too much more to add on the background or the importance, but I'm here for questions from the committee, and I'm happy to answer them. But again, it's a simple change. This change mirrors what appears currently in the federal bankruptcy code, so there is a larger precedent for having unpaid child support, having a slightly higher priority than unsecured creditors like credit card debt. So thank you for this time and thank you for your consideration.
Thank you, Mr. Chair. This is an interesting bill. I can't recall having seen one like this, so I am intrigued by it. I'm just curious about some of the items near on that list to where you're placing this and what they mean. What are family allowances, first of all?
So under the Estates and Trust Code, a family allowance is an amount paid to the surviving spouse and children from an estate. It's kind of an off-the-top distribution of estate assets to those individuals.
And so a surviving spouse gets $10,000 and an allowance of $5,000 for each child under the age of 18.
Okay. And so this would presumably be not a child with, this would be a child outside of that distribution for sure.
Well, the child could be a child of the decedent, but they probably aren't husband and wife anymore. The spouses, they're probably not married if they're receiving child support payments.
Okay.
Or were never married.
So it's not, there's no chance of that category double covering later. Okay. And then on the taxes question, taxes due by the decedent. So if we put the order of them, if you put it before number 6 or after number 6, does that I assume that changes what the state gets? That if you took taxes out, paid the state taxes first, they would include that amount in the, I guess, the gross taxable amount. But the person receiving the money, receiving the child support, would also pay taxes on it? No.
So the taxes, so under most of, if you're a child, would be an exempt from inheritance tax. And also, if you're owing child support, there's a very good chance you're not subject to an estate tax, at least not right now. So these taxes are, likely are income taxes. So if a decedent dies owing the state of Maryland unpaid income taxes, yes, this would we're proposing a higher priority than state income taxes. And again, that's the same priority as currently under the federal bankruptcy code. So there is sort of a precedent for having this trump basically income taxes owed to the state of Maryland.
All right, sorry, I just want to understand this clearly. So just a real world scenario here. Someone dies, they were a deadbeat, say, and they have a lot of backed up rearages on child support. Do you have any ballpark of what these kinds of numbers in the real world that you've seen might look like?
It really varies. I don't have a specific number, but it can vary a great deal if it's been going on in arrears for years or a few months.
Could it be 100% of what's left?
It could be.
It could be. So
I can't. Yeah, it could be.
And I would say that many of these things could be 100% of what's left. Like, you could start at the top. Like, some people die with very few assets, and so.
I'm just trying to square what, but I guess if there's some comp elsewhere in law where we forego collecting our taxes before the distribution happens, then I suppose I can't argue. But that's my question, given some other things that we're worrying about this year.
And Secretary Lopez wrote in his letter of support for the bill that this mirrors federal law.
Okay, all right, thank you.
Delegate Taylor, then Phillips.
Yeah, I have a simple question. Can you remind me what the 5 payments are above number 6 now, which would be the child support?
Fees due to the Register of Wills, costs and expenses of administration, funeral expenses, compensation of the personal representative is provided in the statutes, and the family allowance is provided in the statutes.
Compensation to whom, I'm sorry?
Compensation to the personal representative.
The personal representative. Okay, thank you. So that's not even.
Delegate Phillips.
I thought I would be remiss if I didn't welcome the Register of Wills for Baltimore County to our session here today. So I'm just taking that opportunity. But you said something that I think is important. The mentality of our estate system definitely defers to family and children. And is this consistent with the objective of our estates and trust system today?
Well, that's a kind of softball question, but yes, I appreciate that question. It really does. I mean, the Estates and Trust Code is designed to help families get through a really difficult time of losing a family member. So that's why you do have the spousal allowance and the family allowances. And we do have an interest in protecting the vulnerable children of decedents, and that gets at the spirit behind this, that if you have a vulnerable child or family struggling to get by, and if you die with owed back child support, that could be months or years that the surviving parent went without those payments and had to scrimp and save, maybe even needed to have public assistance in order to make ends meet or feed their family and things like that. So that was sort of the point of child support and child support enforcement, to ensure parents take responsibility for their children and relieve the state of the burden of the cost of that when there is a parent who's able to do that. So this really follows through with that policy of protecting children and making sure vulnerable children are cared for, and there's someone looking out for their interests.
Thank you. Thank you, Delegate, for bringing this bill.
Thank you. Thank you.
Delegate Embry.
And welcome to both of you. So it's great to see you. This is a question partly because you're both experts, and in reading the existing language, I was curious. So the reasonable medical, hospital, and nursing expenses of the last illness, I was just wondering, who determines what is reasonable and what is the last illness? I just wondered how that works out, because medical debt obviously can be a really significant lien on an estate.
Yeah, so the reason if a decedent is in a hospital or hospice, you see it in that, or in a medical care facility, those are would be the final bills from that. And the reasonableness standard, I've never really seen too much litigated about the reasonableness standard, other than they're actually debts that are owed. They can't make up that number. But as far as I've never seen where someone says, well, actually, this didn't cost that. There's usually receipts to support that, and we do get copies of bills and things from the medical providers at the end. Kathy?
Additionally, the personal representative can deny any claim against the state, and someone has to come forward and prove what they think, and it can go before the courts, and they determine whether the claim is valid.
Thank you. Appreciate it.
Vice Chair.
Thank you, Mr. Chair, and thank you, Delegate Forbes, for this bill. I have a question for you, and then I have a question for the Register. So why not number 1?
The Register's sitting right next to me.
Okay, that's actually for the delegate.
If it were number 1, I'd be really happy to, because I feel like children need to get what they're due. But I also think the fees that are used to run the Register's office, they're a public service every day. They're sitting in there helping people through a really difficult time. making sure they're in compliance with the law and that people are getting what they're doing in estates.
Okay,
I'm a big fan.
got it. And so, Madam Register, what effect, if any, does a will have on this list?
So whether or not a individual has a will doesn't really have an impact on this list because these are expenses and claims of a decedent. So if a person has a will or doesn't have a will, but they owe a bunch of people money when they pass away, whether you have a will or not, you're still able to file a claim against the estate for money that you believe is owed to you. And as Delegate Forbes mentioned, the personal representative can deny the claim and force a hearing in front of the orphans court to really vet the reasonableness of the amount that was claimed, whether it was really due, those kinds of issues. So there's plenty of opportunity for notice and an opportunity for the personal representative to defend against all these various claims. Just because a claim is filed doesn't mean that it's always paid in full. So.
And that's in statute too, the amount of time the personal representative can deny a claim and then how the claimant has to then request a hearing on it. And so that part is in statute too.
Thank you.
Thank you, Mr. Chair. This is a very intriguing bill. Let me ask you this first. So have you seen this model in another state?
So I have not. Here's that. When I am not here in the legislature, I run a mediation program for the Orphans Court of Baltimore County in our probate problem. And so I work closely with the Register of Wills. And this is something that came out of a discussion. Actually, you were doing a training for assistant attorney generals.
In child support enforcement. So I did a training for the attorneys that do child support enforcement for the state, and they were wanting some training on how to file claims and get claims of unpaid child support paid. And that was when I had this realization that your claims have the same priority as an unpaid credit card bill. And to me, that just did not seem right. That doesn't seem appropriate. And whether it's 6 or 1, I don't really care, but I want it to get paid, and and taking care of our children should have a higher priority than many of the other things on this list, especially unsecured debt like credit card debt. So that's where the idea for this came, how I got the idea for this. And when I talked it over with Kathy, Delegate Forbes, she said it was a no-brainer and that we should try to put it in and see what happens, just because it's a really simple change. There's precedent under federal law, and it would make Maryland laws similar to what happens in bankruptcy. And it just seemed like an easy fix to a problem that could really help families in Maryland. Okay. Especially grieving children who lost a parent, and it's always financially difficult.
And if they were getting this child support, there's no more of child support coming. So if they can get the back stuff that was owed to them.
Well, that brings me to my next question, and I don't know the timing of this, but I'm just curious. Being you are an expert in this space, the Social Security survivor benefits, how does that align with the timing of the decedent passing to the child or survivors receiving that benefit?
So that's a little outside my wheelhouse in terms of the survivor benefits. I just know from anecdotal family members, I had a cousin who passed away very young, and it took a long time for his surviving spouse to access those survivor benefits from Social Security. But that's all. I apologize. I can get the answer to that question, but I don't want to claim that I know the answer, because I'd have to look it up.
Sure, that would be great, thank you.
Okay.
Because I'm just curious, even though, yes, we might move it up on the list, we still have children that still need resources when the deceased parent is gone. And with that being said, I was just curious, how soon does that come to play? In fact, if that person who is deceased, they might not even have anything to work from. So I was just wanting to know, but thank you for your time.
Yeah.
Thank you.
All right. Delegate Kaufman.
Yes. Thank you very much, and I think it's a good bill, but I'm going to ask a similar question to what I asked Delegate Conway on his porch piracy bill yesterday, and that is, both of you work at the court, and so how prevalent of an issue is this where a parent has not paid their child support and even upon their death haven't paid it? I'm just trying to see what the scope of the problem is. And since Baltimore County is a large county, I thought you might have some insights.
It happens a few times a year. I wouldn't say that it's, every day we see this. It happens a few times a year where someone will call and, they'll ask a question about how to file a claim for unpaid child support. So it's not it's not going to happen every day that the state of Maryland is losing out on back taxes because someone filed a claim for unclaimed child support, but it does happen. And it happens often enough that the Division of Child Support Enforcement had a training at Turf Valley, invited me to speak on this process. I can comb through some of our claims data, and I could get you a better number, a more specific number, at least for Baltimore County.
That would be wonderful, thanks. Go ahead, I cut you off there, sorry.
I was finished, thank you.
Thank you, Mr. Chair. You got it, you got it. And thank you for presenting this bill to our committee. I'm just curious because I'm not really familiar with the trust setup, but let's say you have siblings that are in this trust and the child support is unpaid. Is that debt shared among all of the family members or how does that work? Let's say you have, like I said, you have 3 siblings and the brother has $50,000 in unpaid child support.
So I think you're two things. Trust, you used the word trust, and
Okay.
trust wouldn't come through this because these are only probate assets. So assets that go through an estate. And the other thing is, if that brother was to inherit, is that what you're saying? They were going to inherit and they had unpaid child support. It would come out of their share.
Out
The
of
claim
their
would
share
come out of their
only.
share of
Okay.
their inheritance.
Okay, I see. All right, thank you.
All right. That elicited way more questions than I thought it would. Thank you very much. That concludes the testimony on House Bill 261. Before we go now to the next bill, so not just yet, I know, I'm getting to you, Delegate Conway. I would want to call up 2 people to the table. There are no more questions. We're done with.
Thank you.
We're throwing you out.
Thank you.
Thank you very much. I want to ask 2 people to come to the table. Evelyn Troy, please. Come on up. And Joyce Bongjo. Come on up. Welcome to the committee. Ms. Troy, I understand that you are working for a member of the committee this year. Is that correct?
Yes.
Who is that?
Delegate Crutchfield?
Delegate Crutchfield, is she a good boss, or is there something you want us to know?
Yeah. No, I love having her as a boss.
All right, all right. Where do you go to school?
I go to UMD College Park.
I'm sorry, it's at College Park?
Yeah, UMD.
All right, thank you very much. What year are you in?
I'm a sophomore right
Sophomore. Very nice to meet you.
now. Nice to meet you too.
Please.
Hi, I'm Joyce. Last name's pronounced banjo, like the instrument.
Banjo, okay, that's great. And are you working for someone on the committee this year?
Yes, Delegate Nicole Williams.
Delegate Nicole Williams. She okay? I mean.
She's amazing.
Oh, she is amazing. We thank you for coming and being an intern here this session. Thank you very much for putting up with us, please. And that extra couple minutes there allowed us to spend a little bit more time before we went to Delegate Conway's bill, but also allowed Delegate Cardin to get here. Look at this time management. Delegate Conway, come on up. Delegate Conway, please. Delegate Conway.
Can we applaud him too?
What? If you would like, or if you write a note saying that and send me a text message. But if you tell me, I will sometimes forget. Yeah, well, I'm just saying. Delegate Conaway, please.
Thank you, Mr. Chairman, members of the committee. I'm Delegate Frank Conaway, here to introduce House Bill 252, Real Property Actions for Wrongful Detainer Required Postings. I'd like to give this one to you from the heart. Uh-oh. Sometimes there's loitering and trespass before squatting. I'm aware of one community organization that tried to quash this type of situation by reporting the specific property address to the president of their community organization. And they were told by law enforcement subsequently that law enforcement could do nothing because there was no signs posted that said no trespass, no loitering. Then the law enforcement decided to show up at the community meeting, and they specifically said what address it was, and it was the wrong address that was identified by the community organization. Subsequently, the community organization demanded that sign be posted on several properties to say no loitering and no trespass, so law enforcement could take an action if someone said they were given permission by the homeowner or the tenant or resident to be on the porch. And therefore, I'm putting this bill in to say that you're required to put up the posting to say no loitering or no trespassing, so law enforcement can do their job adequately if that is correct. I'd be glad to answer any questions if I can.
Questions? Okay. I don't have any questions.
Thank you very much, and I would ask for a favorable finding.
We have two people in opposition. Two people in opposition to the legislation. And possibly one of the more interesting alignments this session, Matt Hill and Bill Castelli. Matt Hill from the Public Justice Center and Bill Castelli from the Realtors. So,
unprecedented.
I'm kind of interested to see how this is going to go. Who would like to go first?
Sure. Thank you, Matt. Thank you, Mr. Chair. Bill Castelli on behalf of the Realtors. And the Realtors are opposed to the legislation. We do appreciate some of the delegates' other legislation on wrongful detainer actions, but do have a problem with posting. Under criminal trespass law, there is a requirement for posting, but for wrongful detainer, which would be an action where an owner of property, typically it would be a squatter who's broken into the property, would pursue that civilly. They would have to go to court because that person had never had any kind of legal possession of the property and use a wrongful detainer action. So the concerns that our folks have is that in instances where a person has broken into the property, the likelihood of them removing signs, postage, you would have to, we believe, demonstrate in a timely way that when that person occupied that property, that sign was posted at that time. So we're very concerned about what level of proof we would have to demonstrate to a court in order to access a wrongful detainer action. And that really is the only remedy in a lot of these situations for trying to remove someone if a police is or law enforcement is uncomfortable with trying to remove them through trespass. So for that reason, we would oppose the notice requirements.
Thank you, Mr. Chair, members of the committee. My name is Matt Hill. I'm an attorney at the Public Justice Center, and I appreciate the sponsors articulating the rationale for the bill. I admit when I read the bill, I took away something different, and so my testimony was geared to what I read in the bill, which is the way I interpreted the bill says that for these wrongful detainer cases, normally they don't apply, in particular if someone is a renter. But if this bill passed, the way I understand it's worded, someone could still be a renter, and yet the owner could use wrongful detainer as long as there was a sign posted saying no trespassing. And if my interpretation is correct, what that would do is allow an owner to bypass the whole body of landlord-tenant law if there was a sign posted saying no trespassing. And so maybe I'm not reading this correctly, but that was because it's certainly not what I think the sponsor intends. But that's our concern, is that, to Mr. Castelli's point, these signs go up, these signs go down. We see just so many people who are a victim of scams. Someone says, oh, I'm the owner here, let me give you the keys, give me your $3,000, and you can start renting the property. Sometimes they get a lease, sometimes they don't. Sometimes they get a receipt for their payment, sometimes they don't. Sometimes we'll see renters where there's a property management company that leases them the property. But then when they get in the property, 2 weeks later, they get a knock at the door, I'm the owner, you're not supposed to be here. And it's a dispute between the property management company and the owner. We'll see some landlords who say, well, I'm gonna rent you this property, don't worry, we'll shake hands, give me your $3,000, and it's in cash, there's no receipt. Tenants, they're desperate for housing. I mean, you all know how unaffordable the market is for so many very low-income folks. So they move in, they've got the key, they think they're good to go. But wait a second, there's a leak in the ceiling. There's no heat. They start to complain. And the landlord says, well, man, maybe we don't have a landlord-tenant relationship anymore. Maybe I can just file a wrongful detainer case. Unfortunately, it happens. And so, but I'm not quite sure about the purpose of this bill. I think what my interpretation is very different from what the sponsor intended.
Questions? Delegate Eric.
Thank you, Mr. Chair. Thank you guys for being here. So now that you sort of understand what he was actually trying to get at, is there a fix? Can you recommend, how would you word it so that we can accomplish what his goal was and not complicate this landlord-tenant issue you're talking about?
I might say, maybe under, there's under trespass law, criminal trespass law, you have both just the normal trespass, but you have wanton trespass, which doesn't necessarily require posting as long as there is communication, from the owner to the other party. I don't know if that.
So a verbal command, or that'd be hard to document, I would imagine. So, I mean, a sign posted,
normally,
people
yes,
know.
it's difficult, and that's why under, you've got essentially two under criminal trespass, the postage, but you're correct, under wanton trespass, it usually needs to be observed by a party. It might in a retail situation be
Okay,
used,
but would it give police enough to go and clear the area?
I will tell you that's, a lot of situations, even with real property, when someone's broken in, there may be a complaint to law enforcement initiated by the property owner. And police are reluctant many times to take action because they might think the person, they're not sure if that person is subject to a lease,
right,
or, maybe they're just a tenant holding over, as
right,
Mr. Hill indicated. So I don't know, it's hard to know what would give the police more confidence to take action.
You're not supposed to be here, please leave. Okay, all right, thanks.
Delegate Conaway.
Mr. Chairman, thank you, panel, for coming in to testify. If one of the members that are sitting here today gets a phone call that they have a group of people sitting on their porch, can they have those people removed without a no trespassing sign off their porch?
I am definitely not an expert, but I would say
You're an
that.
expert on my bill, right?
But I would say this, that if they called, they are in possession of the property, they are the record owner of the property, they have people on the porch. At that point, those people are trespassing if they're not leaving that property. So the law enforcement in that instance should be taking action to remove them.
Well, I don't think that was the testimony that you heard, but if the community association or community organization calls and says, there's a nuisance starting on this porch, and there are people gathering that don't look like they're from the community, is law enforcement allowed to maybe investigate and remove those people without contacting the owner?
I mean, they're certainly allowed to investigate, but yeah, I understand what the problem is.
Well, I don't know about that in Baltimore City, because under the consent decree, are they allowed to investigate for wrongful crossing the street? I mean, we had a problem with search and frisk and identifying people and assuming that people are doing certain things. So I don't know if that's accurate.
All right.
Thank you very much.
Yep.
Any other questions? Seeing none, thank you both very much. That concludes the testimony to House Bill 252. And now 4 bills from Delegate Cardin. And we'll call him up. We'll start with House Bill 27. And Christine Hubbard and James, why not? James Silver. We'll just have everybody. It's up to you.
We can have everybody, and there's one person who came with favorable with amendments. He can come up as well.
That's fine. That's right. That's what I was going to do. So Christine Hubbard, James Silver, come on up. And Delegate Cardin, whenever you are ready to begin with your 3 minutes.
Thank you very much, Mr. Chair, members of the committee. First time here this year, very exciting. We have we have 6 estates and trust bills from the bar, 4 of them today and 2 later in the session. This first bill, House Bill 27, I asked for a favorable report on it. It, for all intents and purposes, creates equity. What it will do, it will make trustees who are not financial institutions or attorneys who have to do a tremendous amount of work be able to be compensated equally or fairly for what they do. And those who don't necessarily do a lot of work also would be compensated fairly, regardless of the size of the trust. That's basically what it does. It's a recommendation from the bar because there are a number of trustees who are working hundreds and hundreds of hours on small trusts that they have a fiduciary duty to make sure that they are doing the proper work to make sure that the beneficiaries of that trust are getting what is owed to them, and they're barely being compensated because it's based on the size of the trust. So if it's a small trust, they're only going to get a small 6% or so of that principal as their payment. So if it's a $500,000 trust and they're doing hundreds of hours of work, they could get a few $1,000s after all that. Whereas if it's a large trust, $20 million, and it's all in a mutual fund and everything's being taken care of electronically, and the trustee doesn't do any work, maybe does a half an hour a year of filing papers properly with his accountant or his attorney, and he could get paid tens of thousands of dollars on that. So the bar believes that's an unfair way to distribute the money to these fiduciaries of these trusts, so they're asking for this legislation.
Thank you. Good afternoon, Chair Clippinger, Vice Chair Bartlett, distinguished committee members. My name is Christine Hubbard, and I'm here representing the Maryland State Bar Association Estate and Trust Law Section in support of House Bill 27, which seeks to amend Estates and Trust Section 14.5708 by removing the trustee compensation calculation based on percentages of income and principal of the trust and replacing it with a reasonableness standard contained in the Uniform Trust Code and now adopted by most states. We are not seeking to change compensation for guardians or Maryland lawyers or financial institutions who are entitled to file an increased schedule of rates with the state. We have run this by the Maryland Bankers Association and other stakeholders without objection. So under current law, unless the trust provides otherwise, these individual or family trustees are sort of stuck with this rigid structure based on percentages of income and principal. For example, if you have a $1 million trust that may generate about $3,100 for this trustee who may work 100 to 200 hours as a trustee, a fiduciary with potential for personal liability. Under this bill, we are looking at new law that would allow this type of individual trustee to be entitled to reasonable compensation under the circumstances, taking a list of factors into consideration to help make those determinations. And we have Maryland case law and UTC comments. So I ask that you please help improve the Maryland trustee compensation laws in Maryland by voting in favor of House Bill 27.
Great job.
Great, thank you very much. So now, committee, we're going to hear from James Silver. Mr. Silver, who's testifying is favorable with amendments, just to be clear. Thank you, sir. Go ahead.
Yes. Good afternoon, Chair, Vice Chair, and committee members. My name is James Silver. I am the supervising attorney of the Adult Guardianship Program with Maryland Legal Aid. Maryland Legal Aid is the largest nonprofit law firm in the state of Maryland, and my program is provides court-appointed counsel to alleged disabled persons subject to guardianship actions, including guardianships of property. We generally support efforts to equalize and make fair compensation for guardians' property. The one request we would make for an amendment to this is that the income be defined to exempt the first $1,000 of monthly payments from Social Security benefits, from the calculation of income. That's because in many cases, our clients who are under guardianship of property, their only income is Social Security, SSI, or SSDI. The maximum SSI payments per month right now are $967. So if a year of payments would come to just over $11,000, that would allow a guardian of property to seek 6.5% of that as the payment for the year. That would be about $750 being paid from the people who can least afford it, and particularly in some cases we would be concerned about a guardian of property that's operating on a mass scale and just getting multiple people that they're doing very little for, but still getting $750 a year. So aside from that concern, we would urge favorable passage with that amendment.
All right, questions from the committee. Delegate Kaufman, then the vice chair, then Phillips.
Yes, this is a question for Delegate Cardin, although you're certainly welcome to defer to your experts. I see, I am a little bit concerned regarding repealing specific things because the law currently outlines if you do this, you're going to get X dollars. And what I consider reasonable, Sally or Susie might have a different definition. So if you could, and especially with special needs trusts with people with disabilities needing care for the rest of their lives usually, I am concerned about the reasonableness because the definition is going to vary from person to person. And so if you could talk about some of the factors that go into it so we don't have people saying, oh, I think $1 million is reasonable, that would be great.
First of all, it's a great question, and I'm going to defer, but let me just interject. I asked that exact same question to the bar because that was very much my concern. And the response that you're going to get from Ms. Hubbard hopefully is going to satiate your appetite. Let me start off with that first of all, the reasonableness has to be justified, number one, and you're going to say how, and she's going to go into that. Number two is if a trustee objects, then a court gets to decide what the compensation is going to be. So there's due process to make sure that it's done. And number three that I would say, because this is kind of what I got out of it, is these people have a fiduciary responsibility. They are required, they are liable, they are personally liable for doing something that is inappropriate. So if they do something that's inappropriate and then it is questioned, they could be on the hook. And don't you want people who are trustees of particularly trusts of people with, whether it be with disabilities or people of special needs, to be those people who understand the fiduciary responsibility, and we want to compensate them properly. So I will say that, but to go into the details, we'll let Ms. Hubbard speak to that.
Yeah, it is an excellent question that we are concerned about as well. That's why we look to the Uniform Trust Code. It's extremely important that we did not deviate from that language other than to put a list of factors. So we have in this bill and what would be in the new law, a list of factors to help guide the determination of reasonableness, including the value and character of the trust property, risks and responsibilities of administering the property, the time that is spent. So I always encourage trustees seeking reasonable compensation to keep a log of their time so that, they should not be paid $100 an hour for cutting the grass on a house that needs to be sold. But if they are working with accountants and lawyers and their bankers and, working on tax returns and, dealing with matters that require a high level of skill, and they may in their personal jobs be garnering substantial hourly pay, they should be paid reasonably based on even skill sets that they are bringing, the cost and character of services that they are looking for third parties to bring. So there's that list of factors that we would use to carefully determine reasonableness. And as Delegate Cardin said, if a beneficiary believes that compensation is not appropriate, they may absolutely go to court to have that determination overseen and determined by a court. So, we are going from a rigid standard that does result many times in the underpayment or sometimes overpayment of compensation. But we want a new structure that is, again, for good reason, it is adopted by the Uniform Trust Code or recommended by the Uniform Trust Code, designed by, teams of people working within, working with the Uniform Trust Code to create this language. And most states have adopted it for good reason. So we're going from a rigid standard that can result in, unfair pay, does not reflect the value of the work done, to a more subjective standard, yes, but certainly a more fair standard that you always will have the oversight and intervention of a court if it is abused. A trustee is a fiduciary. That has obligations to the beneficiaries to not abuse that office, to not overcharge, and to act fairly. So I hope that addresses your concern.
Yes, with your indulgence, Mr. Chair, I have a brief follow-up if I could. Thank you very much, because serving on this committee for me is like law school without the debt, so I'm learning so much. But the thing is, Delegate, I am still a little bit concerned. So you articulated that if somebody is found to behaved inappropriately, there will be consequences. So can you give me a couple of examples of the sanctions that people will be facing? Because I want to be assured that, there's skin in the game if there's misbehavior.
Sure. So, well, first of all, they could be removed as trustee. The court can order funds to be returned. If there is abuse or there's an abusive charge against the trust, a court can monitor that and require funds to be paid back. So, if there is thievery by a trustee, they're acting in bad faith or self-dealing. There's also even criminal charges that can be brought. So, there is oversight by a court. So there's a whole host of remedies that can be sought by beneficiaries against a trustee who is acting inappropriately in violation of the trust or law.
Well, I thank Professor Cardin, going on my earlier theme, and I yield the floor.
Professor now? Taylor.
Oh, well. Okay, thank you. I, too, am learning a lot about all of this. And, I'm hearing you saying trustee over and over, but I thought we were talking about guardians, right?
We're talking about not. And thank you for asking that question.
Okay.
Am I?
No, please.
So we are not seeking to change guardian compensation at all. There's a whole task force, a guardianship task force that has been working for about 3 solid years on a guardianship reform bill, including reform of the guardianship compensation. Because I agree, it's really rock bottom for guardians of property that do a lot of work. But we are not choosing to mess with guardian compensation. That's why, let me just explain. The Estates and Trust Section 13-218 states that a guardian, unless there's other provisions for a guardian, that guardian is to be paid the same as a trustee. So it points to 14.5708. And they are required, 14.5708I says guardians cannot file a schedule of increased rates, like Maryland lawyers and financial institutions. So they're stuck with that calculation based on percentages of principal and income that we are removing or seeking to remove. So then the cross-reference wouldn't work. So all we're seeking to do with guardianship is to take the provisions which have those calculations of percentages of income and principal and shift them out of 14.5708 into 13-218. That's all we're doing. We are not changing them at all. And we really don't want to sort of amend to just tweak it, because that's not our arena. You know, we don't want to, again, mess with the guardianship compensation provisions and where we want to allow the task force to do it. We talked with the lead of that guardianship task force and some of the guardians of property, some of the attorneys that act as court-appointed guardians of property, and they actually did not want us to mess with it at this time. There's a sheet for guardianship commission, guardian commission worksheet that they fill out, and so long as they stay within those standards, those formulas, their compensation typically gets paid without review, without issue.
Right. And I noticed on page 4, there's a limit to the amount of compensation a guardian would have if they're a guardian for a person that's disabled under a Medicaid program.
Right.
So that doesn't seem to be fair either. You're limited to $50 a month in compensation.
And I have a feeling that when the task force comes back with recommendations from the bar,
that's going to be changed.
That will be coming to us next year.
My last question has, I guess, if it's okay. Who are these trustees? Like, give me an example of who they are.
A son, a daughter, a friend.
Okay.
Yeah, it could be mom passes away, then dad passes away, and there's 4 children.
Got it. So like for my instance, I have a guardian, a trustee appointed for my children. One's responsible for fiduciary, one's responsible for healthcare kind of stuff, right? Now, but I've had an example in our community where a trustee has someone died, there was the estate and all. The trustee actually took money from the estate away from the family members because they were the trustee of the estate. They sold property and took the proceeds from that property. So it seems to me a trustee already has some way of being compensated if there's money in the trust.
So it would depend on what the terms of the trust are. In that situation, that is not something that we're dealing with here.
This is something different.
That if the trustee is managing the estate in ways where he or she is selling property or just dissolving assets,
right?
Should be, as a fiduciary, doing it by the terms of what the estate, what the trust is telling him he's supposed to be doing it for, to the benefit of the beneficiaries. as per the details of the trust. And if he's not, then you go into the question of whether he's doing something wrong. And that's a different story, a different scenario, which is going to be dealt with by the court
Got it.
through complaints filed.
Right, so this only applies if the trust instrument does not indicate trustee compensation. And under Maryland law, beneficiaries have rights. They have a right to a trustee's report. That trustee needs to account for what they're doing to the beneficiaries. It's really, really great that we have that bit of oversight by the beneficiaries. They can object. And when they have a trustee like that, they can bring that trustee to court. Because that's not compensation, that's actually misappropriation.
Got it, thanks.
Okay. And with Delegate Phillips' forgiveness, I have been observing a fellow member of the committee who has looked anguished before she now has pressed the button, and now looks even more anguished. But Delegate Pasteur has a question.
So, then I fix myself. Yeah, and I'm still on the person from last session and the watch. Okay, so I have grown in my own sanity to trust Delegate Cardin in these matters. I know, it's frightening to me. Because I have all of these issues. Now, until Delegate, look, I can't even think of her name, Taylor asked that question, and I know you were trying to break that down, but it just took me to digging in my hair mode. So you have a guardian, right? And you have a trustee. The trustee, in many ways, oversees what the guardian does, or no? No. Because I always thought they were separate.
They are separate.
All right. So I thought I knew what the guardian did in just real plain language, because even though this delegate thinks he's in law school, I often feel like I'm in the insane asylum. And here I am.
The guardian is while they're living.
Yes, the guardian, yes, I got that. The guardian is while they're living, so we'll be taken care of.
So those are complete.
But
they're
the
completely
trustee
separate.
is?
So the trustee is in charge of assets that are owned within a trust. For example, if a person, a mom, decides to put her house and her investment portfolio in her revocable trust, for example, during her lifetime, and then she dies and names one of her 3 children to oversee the trust, to pay taxes, to pay bills, to value the house, and then distribute that trust property.
Okay.
That trustee has a fiduciary obligation to carry out those duties reasonably and for the benefit of those beneficiaries. This has nothing to do with guardianship. There's a bright line, and over here, that lives guardianship. And the guardian... Different part of the code. Yeah, totally different part of the code. The only reason it's put in this bill together is that the guardianship compensation cross-references the trustee compensation. So that's the only reason why we're talking about guardians and trustees at the same time. So a guardian is there to represent a minor or a disabled person, and they have to be compensated. And so instead of repeating the trustee compensation structure from the trust section, they just cross-referenced it. That's it.
Okay, I have the guardianship. Let's just put that here. All right. But if I'm the trustee, I am not. Can I be a trustee and a guardian?
You can.
You can.
At different times, I got that.
And you could also be a beneficiary.
Exactly, exactly. Okay, that's the piece I needed to understand, because I end up being all of that for everybody. All right, I have it, I think. I have the watch. Oh, thank you. Thank you, Mr. Chair.
And thank you, and I mean this seriously, estates and trusts law can be complex, and there are lots of moving pieces. So I don't mean to make light of it, but when I was watching you listening to the answers to Delegate Taylor's question, these can be fairly in the weeds conversations, and so I am perfectly happy every once in a while to stop the train so that we can take it apart a little bit, because these are the bills that we will all be impacted by estates and trust law at some point. We can't avoid it. So I appreciate the questions that you're asking, and I just meant to intervene a little bit because I watched you and I thought, oh my, he's gonna fall down, and I'm not having that. All right, so now we'll go to Delegate Phillips and then Delegate Tomlinson.
Thank you, Mr. Chair, and thank you, Delegate Pasteur. So hopefully we're a little bit closer to understanding all of this stuff, right? So I want to draw some distinctions, and I was also confused about why we needed to include the title specifically of this, guardians of property and trustees, which leads one to think we're touching the guardianship piece, which you're not. Can you explain to me again why it had to be referenced? And maybe this is just a way it was written by Legislative Services, but.
Yeah, sure. So under current law, 13-218 states that a guardian is entitled to be compensated.
Correct.
In the same manner as a trustee, period. So then that takes us over to 14.5708 that has trustee compensation. And it has different types of trustee compensation. It addresses Maryland lawyers and financial institutions that are entitled to file a increased schedule of rates, which we're not touching. And then it has this formula that we're talking about based on percentages of income and principal. And that statute says guardians are only entitled to that.
To that
Right.
one piece of that.
Correct.
Right.
And that is what we're taking out.
Okay.
So if we took it out and we still have that cross-reference, it would cross-reference nothing.
I got it.
Right?
So we're taking that out of 14. We're leaving it in 13. We're putting it
in.
back in 13. Got it. So the guardian compensation, you're not touching how it's done. You're just taking that and putting it in 13 and no longer cross-referencing 13 with 14.
And you know what? That's the right thing because guardian compensation should be handled differently than trustee compensation. So now it's separated.
Which takes me to a different question, because in guardian compensation, before you can be compensated, you've got to file your report with the court. And so they're all reasonableness and all of that. Is that correct? I'm supposed to be asking questions.
Yeah.
That's
yeah.
correct.
It looks like that. This is like that's the worksheet.
Right. And so unlike, and I think this is maybe where we need to understand, trustee compensation, is there a reviewer of trustee compensation in all trustee-related matters?
The court does not review it, but the beneficiaries may.
Right.
They have a right to.
And so if it's a trust, the trustee is the trustee required to send an annual report to the beneficiaries?
Upon request, yes.
So it's only upon request? Any reason why we shouldn't require them to send an annual report?
Well,
is this something you wouldn't put in this bill as well?
You know something, sometimes it's a very close-knit family and they don't want to make extra work for a trustee because you need to reconcile accounts, you need to get things balanced. It's not easy putting that trustee report together. But I encourage trustees, family members who are trustees to do it, even if it's not requested, so that that beneficiary knows what's going on, right? These were the assets at death. These were, gains and losses, income. These are all the expenses, and this is what we have to distribute. So they understand, because that trustee is going to want to be released from liability. So they don't get released. So under Maryland law, in order to get a full release, you need to provide a trustee's report.
Okay. I think I'm getting closer to being good with this. Thank you.
But you know what? There is no intense court oversight of every single trust as there is guardianships.
You may get some pushback from the judiciary on that of you.
No. I'm not suggesting, because it's really a private, unlike the guardianship, where you're dealing with a minor child, you're dealing with someone disabled. This is a
distribution.
This is a private. This is a private transaction.
Mm-hmm. Because guardianship, that only exists because the law requires it. It's a minor or it's a disabled person. So the law requires that guardianship. For trusts, people choose, and they choose their fiduciary, and they trust that the trustee that they select will carry out their desires.
Thank you.
Last question, Delegate Thomas. This is for you.
Thank you, Mr. Chair. No pressure, since I'm in a classroom in an insane asylum, apparently. No, I'm just looking at the fiscal note, just trying to understand all this. Just easier question. Just what I see it has listed as there's a small business effect. What are they talking about here?
You know, that's a good question, because you don't see small businesses serving as trustees. You know, so the only folks that really can serve as trustee is an individual or a financial institution that meets certain capital requirements. Most of them have federal or state oversight. They have reporting obligations. So I don't understand why they brought that up, quite frankly, because you just don't see small businesses serving as trustees. A trustee has fiduciary obligations to the beneficiaries. Duties of loyalty, duties to not act with self-dealing. And so I don't quite know why that was brought up.
Okay. And the last question. Thank you very much. I believe that's everybody for Delegate Cardin's first bill, House Bill 27. That concludes that testimony. We're going now to House Bill 50. And a different set of characters.
Sorry, guys, more lawyers.
No, that's fine. Okay. All right, so we have Charles Jones and Laura Thomas now, this time with Delegate Cardin.
Thank you.
We'll get 3 minutes. Go ahead.
Thank you very much, Mr. Chair, members of the committee. House Bill 50, asking for a favorable report. This bill establishes protections from creditors by the creation of a trust for certain irrevocable trusts created by an individual for the benefit of the individual's spouse during the spouse's lifetime. So for all intents and purposes, if you create a trust, you die, and the trust is to benefit your spouse, creditors can't come after the spouse in certain circumstances. And that's the intent. Again, it's supported by and asked for by the State Bar. They will explain the reasons why this will be impactful.
Very good. Hi, Charles Jones here, representing the Maryland State Bar Estates and Trust Section Council. We seek that House Bill 55 would be amended, an amendment to, 14.51003, to provide spousal lifetime access trust. I'll use the term SLAT, S-L-A-T, and give it the same protections under Maryland law that are currently provided under Qualified Terminable Interest Property Trust. I'll call those Q-tips. Spousal Lifetime Access Trust, the SLAT, is an irrevocable trust created by a settlor for the benefit of the settlor's wife or spouse, and sometimes other beneficiaries in addition to the settlor's spouse. Slats are created to use the settler's federal estate and gift tax exemption, which in 2025 is $13.99 million per person. To protect depreciation on those assets from the federal estate tax, while providing the settler's spouse with access to financial resources for the settler's spouse's lifetime. When a slat is funded with the settler's assets, some or all of the settler's federal gift tax exemption is applied to the gift. After the slat is created and the gift of assets is made to the slat, the assets and the appreciation on those assets are removed from the settler's estate for estate tax purposes. So during the settler's lifetime, a slat is often considered a grant or trust for income tax purposes. This means that that settlor is, the income on that trust is taxable to that settlor immediately. It doesn't change at all. Okay, so that settler is still paying current income tax. The assets owned by the slat are protected from the creditors of the beneficiaries of the slat because the slat was created by a third party, and that's just trust law. Issues arise when when a settler or the settler's spouse divorce or the settler's spouse dies before the settler. Because of those instances, the assets are no longer accessible by the marital unit as a whole. If the slat is written in a way to make the assets available to the settler after divorce or the settler's spouse's death, well, you keep it.
Thanks, Jess. No, you can keep going. Finish.
Okay. It's very short. The slat assets may be inadvertently included in the settler's taxable estate, even though the settler's gift tax exemption had been utilized. Many Marylanders have engaged in the slat planning to minimize the impact of the federal estate tax when the current federal estate and gift tax exemption sunsets in 2025. Laura, you're here.
Mr. Chair, Madam Vice Chair, members of the committee, my name is Laura Thomas, and I am the Vice Chair of the Estate and Trust section of the Maryland State Bar Association. So to pick up where Chaz left off, under current Maryland law, we do not provide a way for assets that are transferred into these slat trusts to be excluded from a settler's taxable estate if their spouse gives them back some sort of interest in the trust after their death, after the spouse's death. Maryland law does provide a way for assets held in another type of trust to be excluded from a settler's taxable estate, even if the settler receives an interest in the trust property after their spouse's death. Those trusts are known as Q-tip trusts. And like the slat, it's an irrevocable trust created for the benefit of a settler's spouse. If an individual creates a trust that is for the benefit of their spouse, the trust meets criteria under the Internal Revenue Code, and the individual's interest in the trust only comes after their spouse's death, then the individual is not considered the settlor of the trust for estate tax purposes as well as for creditor protection. This allows lifetime Q-tip trust property to avoid inadvertent inclusion in the settler's taxable estate. What the change to Estate and Trust 14.51003 will do is basically put the slat trust under the same protections as the Q-tip trust, with the idea of providing ongoing access to these assets to benefit the marital unit, as well as to support the family and assist them with avoiding federal estate tax. And for those reasons, we urge a favorable report on House Bill 50. And we're available for questions.
Vice Chair. Thank you, Mr. Chair. Okay, so I have a couple of questions.
I bet you do.
So, in fact, the current gift and estate tax exemption will sunset December 31st, 2025, right?
That's correct.
So, what is the current federal gift and state tax, federal estate tax exemption right now?
$13.99 million per person.
Okay, so if we were to make this, if we were to pass this bill and it was enacted, what is the enactment date? What is it, October?
October 1.
Wouldn't it be fixing a problem that doesn't exist yet?
So the issue is they're in anticipation of the sunset of the federal estate tax, many people have created these trusts already. And we're basically just asking for the protections that are extended to a very similar trust, type of trust structure, to be extended to this one. So it's not that the problem still exists, even though the exemption has not sunsetted yet, because these trusts have already been created. They're irrevocable. They can't be changed. So it's just a matter of really the spouse, the settler spouse, giving an interest in the trust back to the settlor. That's really what the crux of the issue is, not necessarily the exemption. The exemption is the change in the exemption is just a reason people have put assets into these trusts.
Okay, I see. So that's just this sort of like a byproduct.
Mm-hmm.
Okay. I had another question. I'm going to say Chaz because she called you Chaz. But
You can call me Chaz, but it's
Okay.
with an S and not a Z.
Okay.
I don't do hair, so it's got to be.
Can you just get into a little bit more how this is a problem at the time of divorce? That's what I was a little confused on.
Sometimes in marital settlements, you'll find that folks, there may be an asset put into one of these trusts, for instance, that is a small business, part of a small business. And as a part of the settlement, it may be that the spouse who is the beneficiary of that trust would continue to be the beneficiary of that asset, that small business, piece of the small business that's in the trust, until such time as he or she dies. And at that point, that asset, they would like it to go back to the grantor, the settlor spouse. To do that, it would cause inclusion in that settlor spouse's estate, right? But if the settlor spouse could become a beneficiary of that trust and continue on, then we're asking that it wouldn't, because they've utilized this federal exemption. And it's a big number, I know, but it could be, if it were a lower number, we could talk about lower numbers. But it allows he or she to have a beneficial interest back in that business as a part of the divorce process where they agree. The beneficiary spouse continues to benefit from that business, but if that beneficiary spouse dies prior to the settlor spouse can, that benefit could accrete back to the settlor spouse without causing inclusion. They would not have wasted their federal estate tax exemption. Does that make sense?
No.
Oh, gosh.
No, let me tell you why. I'm going to tell you what I don't
yes, ma'am.
understand. Okay, I understand. Can we do Party A and Party B just for a second
Sure,
instead of the
Party
true
B.
terms? So we've got Party A and Party B, they are married. Party A creates a SLAT for the benefit of Party B.
Party B.
Okay. They get a divorce.
Party A gets remarried.
And Party A gets remarried. So now we've got C, and C gets the benefit of, is C,
No, C's not a beneficiary.
right, C's not a beneficiary and can't become a beneficiary, right?
That's correct.
Because it's made for B.
It's irrevocable.
Right, and it's irrevocable. So why is it a problem? Explain to me when there is a divorce, why a SLAT is a problem between A, B, and remarried C.
Okay.
Or new party C.
So the issue comes up when A and B have gotten divorced. A has created this trust for B's benefit, and B is receiving this payment. If B dies before A, if B has not given an interest in if B has the ability to give an interest in the trust back to A, and they have done so, in the divorce proceeding, they can actually say, okay, as part of our settlement agreement, you must execute a will that gives this interest back to A if B dies first.
Okay. I think that's as far as my understanding is going to go. Thank you.
Any questions? Seeing none.
That's a tough one.
You get to stay.
D. And now we're going to House Bill 88. Same crew, I thought, of people, maybe not, who knows? But House Bill 88, Delegate Cardin for 3 minutes, please.
All right, this is, we're going back to the decanting law, the decanting section, and we're providing wine for everybody. It just provides or creates provisions governing the methods by which notice may be given, documents may be sent under the decanting law. It's a clarification bill for the most part. I'm sure it will be more complicated as explained, but it is to try to expedite or make easier the distribution of information.
Okay, I'll try to make this a little easier on the ears. Basically, the Maryland Decanting Act does not currently provide a uniform notice methodology. And so this bill is designed to create that methodology so that when a trustee is going to decant a trust, and I gather you've talked about that in the past, what that means.
It's creating a trust from a trust.
That's right. You're not changing the beneficiaries, but you're changing some substantive issue like how to choose trustees or what kind of assets to invest in, those kinds of things. So when a trustee wants to decant, there's no methodology on the notice. So what this bill does is it creates that methodology. And what we'd like to, what the delegate is proposing is that there be a personal service certified mail or first-class mail or postage prepaid, return receipt requested by courier delivery or with the consent of the person entitled to receive notice of the decanting. And that notice would be to the qualified beneficiaries of the trust, to other trustees, and other interested parties in the trust itself. So that's the sum and substance of it all, and I'm glad to see I got that in 2 minutes.
Less than 2, 1 minute.
Any questions?
We'd ask for a favorable.
Delegate Taylor.
How does it work now?
Well, I'll read to you how, sure. The Maryland Decanting Act is not under the same subtitle as the Maryland Trust Act. So the Maryland Trust Act doesn't afford the uses of notice for the Maryland Decanting Act. So we want to link those two up. It does not list a proper method for notice, so it doesn't say how to do it at all. So we want to link up the Decanting Act with the Trust Act to provide, okay, we're going to use the same notice that we use in the Maryland Trust Act for general purposes.
I got it then,
Yeah.
thank you.
And I'm going to read this from the fiscal note so I don't mess up. It says, subject to certain exceptions, the authorized fiduciary must give notice of any intended exercise of the decanting power at least 60 days before the exercise of that power. Notice must be given to each qualified beneficiary. Doesn't say how, doesn't say when, or it says within at least 60 days before. But this kind of lays out how notice should be done.
Great, thank you.
All right, seeing none, that concludes the testimony on House Bill 88. Now we're bringing up Bob Enton to be part of the last panel on House Bill 146. 146 is now, and Mr. Enton is supposed to be at the table. You signed up.
I'm here.
All right. Delegate Cardin for 3 minutes, please.
This is probably the least controversial bill, and even though Bob Enton's here, that I have. This bill authorizes a trustee to resign without having to seek court approval, provided that 30 days notice is given the qualified beneficiaries of the trust, the settlor or creator of the trust, all co-trustees, and any person that has a right to replace or appoint the successor to the resigning trustee. Basically, if everybody agrees is an okay, that they should be able to resign. That's basically what it does. And it's trying to expedite and make things a little easier so that they can save some money and time.
So really, the problem that we are trying to solve here is in older trusts, there was not a mechanism oftentimes stated. So trustees would have to go to court and be released by the judge. And that creates, a problem for the timeliness, judicial economy. It costs money to the beneficiaries of the trust and all the rest of it. The newer trusts, however, we've been putting this language in there of how a trustee can resign, how they're replaced, and all the rest of it. So this is really aimed at some of those older trusts, and they go way, way back, some of them. PNC, for instance, has trusts that are, over 100 years old that don't contain provisions to allow for trustee resignation. You have to go to court every time. So that's the problem that we're trying to solve, and we'd ask that the committee would put forth a favorable report on this.
Thank you, Mr. Chairman, members of the committee. Robert Enton on behalf of the Maryland Bankers Association. We're in strong support of this legislation. Banks act as trustees, particularly in larger estates where you want to have a trustee that's experienced in an investment, in the investment world, and has been in business and, maybe for 200 years. I'll go back to the old days, and maybe some of you remember Mercantile Safe Deposit and Trust. This was a huge part of their business in those days. A lot of banks, that was how banks were titled. It was the XYZ Bank and Trust. And so we have a lot of trusts that are older trusts like this. The bill provides for adequate notice, but it does allow the trustee at some point to resign without having to go to court, or without having the beneficiaries of the trust bear the expense of having the trustee go to court to facilitate the resignation. So for those reasons, we're in strong support of the bill. Thank you.
Questions for the panel? Okay, I think we're about done with estates and trusts for right now.
Until February.
We thank you all very much, and that concludes the testimony on House Bill 146. Members of the committee, just as an aside, before you head out, we have these issues related to estates and trusts, and Delegate Pasteur brought something else that popped into my head. Over the interim, in my apparently endless amount of spare time, according to Patrick, I started taking looking at the video to be a person who is a volunteer lawyer to help people establish wills and other documents that are so important, not just if you have lots and lots of money, but in some cases, particularly if you don't. And so what I would encourage for those people who are attorneys on the committee is to maybe consider getting involved with the pro bono center to find ways to help people in your community to be able to get wills and other documents drafted so that they don't fall into the vagaries of intestacy and things like that. But it's a very important thing that not enough people do. And so I'm just taking this time for a public service announcement to encourage you to get involved. And it's possible that the chair might be encouraging members who are not committee members, perhaps, if we can figure it out and Hunter's head doesn't explode, a way to maybe go across the state with the pro bono people and have events in people's districts who are in the committee who are not lawyers, and maybe bring some of those services to them. It's an idea. I don't know, and his head hasn't exploded yet, so that's fine. One other thing, at 4:30, if you'd like to see something completely different, there are going to be 2 high school teams engaged in a mock trial competition at Circuit Court here in Anne Arundel County in the state of Maryland versus Dana Luna. Another way lawyers get involved, including the Anne Arundel County Bar Association, is that you're a judge in a mock trial event. And at 4:30, I will be taking the bench in courtroom 3E and terrorizing children. So, maybe not terrorizing children, but this is another way that attorneys can get involved, and others can get involved, actually. It's today at 4:30. I don't know what schools, and they don't tell you what schools, because we have to go in completely unbiased, and if I know people, then it's a thing. So, yes, it's fun. With that, we will be back tomorrow with more bill hearings. Thank you very much.
Do we have a joint?
We are at 11 tomorrow, correct?
Yes, we are.
We're at 11 tomorrow, and then we have at 1 o'clock joint with the Appropriations Committee related to DPSCS. Oh, I'm sorry, 2:30. So it's 11 and 2:30. We have a legislation from Delegate Kaufman about child care, child support evaluators, which we think might take a little bit of time, so please plan your lunches appropriately. But that's why we have them sort of spread out in the way we do, 11 and 2:30. Am I right? Hey, one time today.